Hello, folks. This is Darren Coble with Versa Business Partners. For those online on the computer, we'll be bringing up a slide for you to see as we're going. It just has the contact information of our two presenters. We will be getting started here in 1 second. To welcome today, Leigh Freeman from Leigh K. Freeman Attorney at Law. She's the principal there, and she's joining us from the Woodlands, Texas. She actually, I really want to say thanks to Leigh for being our first person to join and to join this effort when I started reaching out to folks to see if we could find some experts to talk to our business owners and business operators out there. Leigh was the first one to volunteer, so I just owe a special thank you to Leigh for that. And then Baili. Thank you. And then Baili Rhodes she's a partner with West Webb, Albritton, and Gentry out of College Station, Texas. And so we're excited to have to cover two parts of the Northwest Houston area this week. And these two folks are going to be talking to us about what we should be considering in terms of legal considerations. What, if we were having a cup of coffee with a couple of attorneys, what would they be telling us to at least make sure we're thinking about as we're going through the process? And so I'll go ahead and ask Leigh, if you would, go ahead and introduce yourself, and then Baili will have you introduce yourself as well and tell us a little bit more about yourself.
Sure. Thanks so much, Darren, for organizing this. I remember when I first got the call from Darren, and so much has changed since then, but what he recognized immediately was the need to get out information to small businesses, especially because there are so many different issues that continue to change. And so just want to thank him for his foresight in getting this put together. Again, my name is Leigh Freeman, and I am a sole practitioner in the Woodlands, Texas. I focus on business and transactional law, representing various small businesses here in the area. And I'm happy to be here and try and share some knowledge and give you some practical tips of some things that you may be running up against and how to deal with them. So thanks for having me.
Great. Welcome. We're excited to learn about the different topics today. Okay, Baili.
Great. Hello to everyone. Darren, thank you for including me, and Leigh, I'm excited to work with you on this. I really echo everything that Leigh has said. This presentation, I think, is just really needed by so many small business owners. I know that as things started happening and changing with COVID, a number of my clients would have just so many questions. I've joked, and I know I told Darren this, that I've probably said, I don't know, I'm going to have to look that up more in the past month than I have ever said in my entire career, because this is such a dynamic and changing area. And we're doing all we can to, get updated ourselves and share that information with our clients. So I'm excited to have a resource to point people to that gives them a jumping off ground to address so many of these things that have come up in light of COVID and the many legislative changes. As Darren mentioned, I'm a partner at West Webb, Albritton, and Gentry. We're a firm with our primary office in College Station. We also have offices in Austin and in Waco, and do business all over the state. We're a general civil firm. We have both transactional and litigation attorneys. I do primarily litigation, both employment law and then family law, which are kind of an odd combination, but right now I'm answering a lot of questions from employers. So excited to be here to share with you guys today.
Great. Awesome. So today with our guests, we'll be talking about the legal considerations that you may want to take. Baili's going to start off today talking to us about managing, if you're managing employees during COVID, what types of things should you be thinking about? What types of things is she finding in the various research she's doing, as well as what she's hearing from her clients on the common questions that maybe she's already looked it up or that she's facing a bunch as they keep coming in. And then we'll move into and have Leigh touch on, let's say that just based on the business economy and the way things are going, you've got to reduce costs and you've got to look at your different options, be it a reduction in force, a small layoff, a furlough, reduction of hours, those kinds of things. She's going to help us think through what we need to look at and what we need to think about as we move into that. Yeah. So we've lost Baili. I'll reach out to Baili separately, and we'll see if we can get this going back. Leigh, how about we're going to make a shift quickly, and we'll go ahead and shift to managing employees during COVID, or I'm sorry, to navigating a reduction, and we'll let you go ahead and start chatting, and we'll get a hold of Baili offline.
Yeah, of course, we know that employers are trying to do their best to keep employees on payroll, but as employers are looking through a reduction in their revenues and looking at how to cut costs, cutting headcount, payroll expenses is obviously going to be something that a lot of employers are going to be considering. We've already heard stories. I'm sure most of us know someone who's been affected by a layoff or a furlough. And so these are always, difficult decisions for employers to make. And what I wanted to do is try and share some considerations that employers should be thinking about when they're in the process of doing these layoffs and furloughs, to make sure that they are in compliance with existing laws. If there are exceptions that may be applicable in this COVID disaster, and if there are, any other unique considerations that we might need to consider, that normally wouldn't be at the top of our list. So in general, when employers are considering doing layoffs, one of the first things you're going to be doing is identifying, what are the group of employees that are going to be subject to the layoff or the furlough. And when I say furlough, most of the time when we talk about a furlough, we talk about either a reduction in hours or maybe a temporary layoff. So for 1 week or 1 month, we are taking people off payroll, but we expect them to have their job back. For purposes of most employment laws and for purposes of unemployment benefits, those whether it's a full layoff or a furlough, if there's a reduction in the number of hours an employee is working, then you're still going to have to consider making sure that these legal requirements are fulfilled. In terms of considering the group of employers, there are a couple issues that you need to be aware of. First, some employees may have employment agreements. So this is typical, especially at the executive level, whereas in Texas, we are considered an at-will employment state, and in most instances, employers can terminate an employee for any reason whatsoever, as long as there's not a discriminatory reason behind that. There are a group of employees that may be subject to an employment agreement. So just keep that in mind, and that employment agreement could provide that there is a term of employment, and it could be considered a breach of contract if you terminate an employee who is subject to an employment agreement. So just make sure you're keeping that in the back of your mind. We also should not use layoffs or furloughs for employees that could be subject to termination for cause. And that has to do with some of the benefits that the employee may be entitled to in terms of unemployment insurance. If an employee is terminated for cause, which is a pretty high standard under the Texas Workforce Commission guidelines for what determines cause. We're talking about things like insubordination, failing to come to work. If you've got an employee like that, they are really falling in a separate bucket and should be treated different than employees that are going to be subject to a furlough or a layoff situation. Another consideration before actually implementing the layoff is whether or not the employer needs to follow the WARN Act, the acronym WARN, WARN Act. So this applies to employers that have 100 or more employees. And under the act, they're required to give a 60-day advance notice of a mass layoff that affects 50 or more employees at a 50%, or more employees at a single site. And people are saying, okay, well, how am I supposed to give 60 days notice? Who knows where we'll be in 60 days? We could have bounced back. Hopefully we could still be in a recovery mode. There's just no way to comply with that act. And so the best advice and best practice that we're recommending is that the notice should still be given under the WARN Act if you do have 100 or more employees and are considering a reduction in force of 50% of your workforce or more, and just send that notice out as soon as practicable. There are exceptions under the WARN Act for unforeseen business circumstances and natural disasters. There's been some questions in other realms in terms of contract interpretation and that kind of thing, whether or not this is a natural disaster. We've had, of course, our different declarations made. But best practice is going to be to still go ahead and provide that notice, even though you may not have the full 60 days and you're still making an attempt to comply with the WARN Act. One common consideration that employers often implement when they are doing a layoff is whether or not they're going to offer severance. So again, unless an employee is subject to a employment agreement with a term, severance is voluntary. Many mid to large sized companies have severance policies of, you know, a few weeks per years of service, or that kind of formula that's in place. If you do have a severance policy in place, we need to make sure that it's being applied equally. So the last thing that we want to do when considering whether or not we're going to have a layoff and implementing a layoff is to whether intentionally or unintentionally violate other potential employment laws that are protecting workers from discrimination. And so again, if you have a company policy that provides for severance and you're going to be allowing, offering severance, then some of the considerations you need to think about are in exchange for the severance, are you going to get a release? That's very, very common. And what that means is that in exchange for receiving the severance payment, which the employer is not otherwise obligated to provide, that the employee will release any potential claims for employment discrimination and other employment related claims that the employee might have. Couple things that we need to keep in mind when we are fashioning those releases is that if an employer has 20 more employees, they're subject to the Age and Discrimination in Employment Act and the Older Workers Benefits Protection Act. We call those the ADEA and the OWBPA. But really what those employment laws are designed is to protect older workers over 40. It is common and in some instances unavoidable that older workers can be affected by a layoff at a rate that is higher than younger workers. And it does, kind of make sense. Employers say, well, my highest paid employees are my most experienced and happen to be the oldest employees. So you just want to be very careful when you're making those considerations and making sure that you're not having a disparate or unfair impact on your older workers. And because of that fact, we do have the requirements to have a notice provision for older workers in their severance agreements. They are required to have at least 45 days if they're part of a group termination, so like a round of layoffs, or if it's just one individual, they need to have 21 days notice. So what that means is that after the employer makes the offer of severance and including those releases, the offer has to remain open, and the employee has up to 45 days or 21 days in order to accept. And again, the purpose of that is for the employee to be able to seek legal counsel and decide if they really, it's really worth it for them to waive those rights that they might have. In addition, so those timeframes can actually be waived. The employee can sign their severance agreement sooner than the 45 or the 21 days, and they are allowed to waive that time frame. However, after they sign their agreement, they have 7 days to revoke their release. That 7-day time period cannot be waived. So I've had employers call me in the past and say, my employee really needs the money, I want to give them the money. You run the risk of having the release voided if you don't wait the full 7 days. Another thing to consider is whether or not you're required to give data about the age and the position of folks that were affected by a group layoff. So again, if you're covered and have at least 20 employees and you're doing a group layoff, you need to provide the employees not identifying information, but sales associate, age, whatever, so that employees, again, this is to help the older workers in order to decide whether or not they should, they might be subject to age discrimination and whether or not they should knowingly waive those types of claims. A couple other questions that have come up is whether or not employees who are on FMLA leave can be subject to a RIF or a layoff. The answer to that question is yes. Just because you're on FMLA leave doesn't mean you wouldn't be subject to a layoff. However, you need to make sure that again, you need to tread lightly and make sure that, for example, all the employees in that person's group are being laid off. If you single out someone who is exercising their rights under the FMLA Leave Act in order to basically retaliate against them, then you could be subjecting yourselves to additional claims. So just be careful if you have workers that are on FMLA leave and want to make them part of your layoffs. And with all of this, it kind of goes without saying that Baili and I are providing general educational type information, but you should really seek your own legal counsel and discuss your own circumstances if you're having questions and considering layoffs, if you have questions about your workers that remain on the workforce. The last sort of practical concern that I wanted to address, and it's something we may not normally consider or haven't normally had to consider when implementing layoffs in the past, is this going to affect your loan forgiveness potential under the Paycheck Protection Program? So I know that we had a seminar, our webinar last time provided employers with a lot of details about the Paycheck Protection Program and other potential grants and loans under the CARES Act. Be mindful that if there is more than a 25% reduction in pay, or if workers are not rehired by June 30th, that may have an effect on your ability to receive loan forgiveness if you are awarded loans from a Paycheck Protection Program. So again, something to keep in mind, discuss with your banker, discuss with your financial advisor, and make sure that you're not losing any benefits that you might otherwise have. So with that, those are kind of some of the general concerns that I wanted to go over when considering layoffs and furloughs. And hopefully Baili can jump in. Did you get your technology working?
I'm good. Thank you so much for jumping in there. And I probably now need to go read some of those articles about being effective on a Zoom conference. So pro tip, turn off your notifications and then don't mute everything if somebody starts to call you. So apparently that's what happened. But thank you, Leigh, for jumping in and flipping our presentation. So back to employees, if you're not in a situation yet where you're having to lay people off, and hopefully you guys, a lot of you are there. As I was mentioning, we've kind of have two categories of people. We've got essential employers who are still working, still have people coming into the office, and then we've got those who are non-essential. And I'm going to talk about both groups of people. The first I'm going to start off with are the essential employers. So how do you know you're essential? That could probably be a lengthy conversation and debate in and of itself, because for those of you who have looked at the list put out by the governor, which then sends you to federal guidelines, it can be pretty confusing. But my first tip on that is you really need to stay apprised now more than ever of applicable orders and guidelines. And that even starts with a determination of, am I essential? As a business, I would suggest that you continue to pay attention to those changing lists to make sure that you're not putting your employees in a situation, or yourself, where you've got people coming to work and they really shouldn't be, both because you don't want to violate, whether it's an order of the governor, local ordinance, whatever that may be. You don't want to be taking action that would be in violation of that. In addition to that kind of overarching, am I essential? Other applicable orders and guidelines that you need to be watching right now as an employer, first of all, is the CDC. They are putting out safety recommendations on a regular basis, and they have good tips on their website, which are applicable to all of us personally, but also individuals who are coming into your office. OSHA additionally has its own COVID guidelines, which is particularly relevant to you as an employer. Of course, pay attention to your state and local government, and then new legislation that is coming out. We've got the Families First Coronavirus Response Act. We could do an entire presentation just on that act and how it applies to you as employers and to employees. And we're not doing that today. I will probably touch on it briefly. But as an employer, I suggest that you not only read that yourself, read the guidance, and then seek legal counsel whenever those things get confusing. So if you're an essential employer and you have people coming into your office, employees in particular, also clients, you need to take steps to make sure that your employees are safe. Something to keep in mind, OSHA always requires us to provide a safe workplace for our employees. And right now that can be particularly difficult to do because of COVID. And so what I'm telling my employers that have asked, they say I'm an essential business, what do I need to do? Look, that's going to look really different industry to industry. If you are a hospital, that's way above and beyond what a typical office that's deemed essential needs to be doing. So I'm not talking about hospitals, because you'll have a whole other list of things you need to do. But if you're a day-to-day office business that is essential and has clients coming in, we suggest that you ask your employees if they're coming in to take extra precautions in the office, maintain the social distancing protocols, hand sanitize, take extra steps to whatever cleaning you've been doing, increase it. And this is where I point you back to the recommendations of the CDC, because they have, kind of the most up-to-date advice on there that we have at the time. But it's important not only to be doing it, but to let your employees know that you're doing it. This also includes watching who's coming in and out of your office and minimizing that even as much as you possibly can, whether that's having delivery people, say, drop things outside the door, encouraging meetings between your office staff and clients via Zoom or telephone conference. Even though you're essential, it doesn't necessarily mean that you should be operating business as usual. People coming in and out all the time. You still need to be taking steps, and I think OSHA would tell you that, to provide the safety protection that you need to be providing right now. So stay on top of those recommendations. Again, as things change, there are a number of good resources, but I think it's a good idea to make sure that you yourself as an employer are reading them. And then I'd consult an employment attorney if you have any questions, because we're all trying to learn what this ever-changing landscape looks like. You also need to develop a protocol for employees who are sick or have been exposed. I think all the guidance that we've been reading says that they don't need to be coming in, they need to be staying home. And if you have reason to believe that your entire workforce has been exposed, you have to notify your employees that they need to know that they've been exposed and that they need to take precautions. But remember, privacy rules still apply. So when COVID happened and we got these new regulations, we didn't just throw everything else out the window. We still have all of the discrimination acts. You heard Leigh talk about them as they come into play whenever you have employees being discharged, but we still have the Americans with Disabilities Act to consider. If you know that one of your employees, say, has COVID, and that you have other employees that were potentially exposed, you can notify them and say that, you've been exposed to COVID, but you don't need to say, Jim in office 307 has COVID, everyone, be warned. That would be a privacy violation and could get you into trouble. So I think that don't forget those rules and laws are still out there. It can be so easy to sort of get in this emergency space and forget everything else that you've been following and that you've probably been really mindful of during all of the time you've been operating your business. As I said, you want to really think about your client, office, employee interaction. Just because you fit that definition of essential doesn't mean that you can't take additional steps to protect your employees. And it's going to look different across every industry. But I encourage you to be really mindful about thinking about the way that you can continue to perform your business with minimal contact and with minimal risk to your employees, even though you do fit in that essential category and you get to stay open. One important thing there, if you are taking steps though, say to minimize the folks that come into your customers or clients that come into your office, you don't want to refuse to do business with someone because of potential contact. That could be deemed discriminatory. You can say to them, we're not currently doing face-to-face meetings. You can ask them, that they not come in the office if they've, there's the list that the CDC has, but CDC, traveled, fever, we've probably all been asked those questions. You can keep people from face-to-face interaction, but don't say, oh, you've got a fever, we can't help you, because that can cause you some problems. So again, don't throw all those rules out the window. That's kind of my overarching theme today. So we've got the essential employers. We also have this whole other workforce of people that have suddenly become at-home employees whenever they have never expected to be that way. And we have companies doing their best to keep people working so that they can continue to operate as a business and keep paying their employees, keep them around. So I have a few tips for managing the employees who are at home. A lot of these are more just kind of practical advice as opposed to legal advice. Our law firm has a bunch of people at home too, and so we're all trying to do our best to work together to still be really effective. And so I've been reading all these articles and studying the best way to work in teams while we're not getting the face-to-face time that we're all used to. So the first thing is, back to my reminder that all the rules still apply. They're still going to apply to your employees who are at home. So just because they're working from home, they can still take a sick leave. They could still potentially be entitled to benefits under the Emergency Family Leave Act if they meet the requirements there, if they come down with COVID. So you don't get to say, oh, well, I've set you up with a home office. I'm sorry that you have this illness. You have to keep working. If they somehow otherwise could, whether it's FMLA, the Emergency Response Act, could qualify for some kind of benefits there. In terms of being effective with an at-home workforce, some recommendations. One of the big ones is connectivity. There's a lot of kind of different studies coming out. I even read one from the A&M Communications Department today that was talking about just utilizing that contact that you typically have in an office, walking down the hall or in the break room, remembering that people tend to feel isolated when they're at home. So I would say be intentional as an employer to reach out to all your employees that are at home and still working from you, just to make sure that, they know you're there, you appreciate them as an employee. I don't know, have a Zoom conference with your team for 10 or 15 minutes and don't talk about work, to just continue to foster the relationship and the atmosphere that you've had with your business. And it can look different from person to person. I know that one of our partners here is calling people every day, and not the whole office, but picking groups and having a phone call. Another one is getting his, different teams he works with together for Zoom conferences. They can have face-to-face interactions. Firms are doing, or not just firms, companies are doing Zoom, happy hour or social hour. It doesn't have to be an hour. It can just be 10, 15 minutes, but don't forget the importance of continuing to kind of foster your office environment, because it's going to help everybody feel a little better and be more productive for you at the end of the day. Now more than ever, when you're a non-essential employer, whenever your people aren't in the office, but you're expecting them to work, clear expectations are very important. So thinking about it from an employment lawyer perspective, if we're on the other side of this and you as an employer come in with concerns that you have about a particular employee and how they have performed their job during the past 6 months, if you didn't do a good job defining expectations and what you wanted them to get done, it may be frustrating for you to make employment decisions down the line. So I would suggest to go above and beyond what you would normally do in talking to somebody about, say, a project or how you want things to look or how you want to get them to be done, just to really communicate often and clearly communicate with them. And that goes to employees too. We all need to be being intentional about our communications. I also say give a little grace, particularly if you're in a management role. Many of your employees are working from home while caring for children, while homeschooling. We're all learning to do this, or most of us are, for the first time. So do think about that. That's not legal advice, but it's practical advice, and I think it'll result in you having a happier company on the other side of all this. Otherwise, just some other overarching considerations for employers. You do need to be probably creative. I'm sure you are all having to be that way to set up at-home workforces, but you also need to be consistent. So if you're an essential employer, but you're letting people, let's say some of your employees are capable of working from home, and they come to you and say, I'm capable of working from home, I'm going to keep working, but I want to go work from home. It's fine to let them do that if that fits within your company's policy, your company's abilities. It's not a problem. But you need to make sure that you provide that option consistently across all of the employees that you have, because that can really quickly start looking like discrimination if you let a certain group of people, go home. Now, if they're different levels, that's kind of a different story. But if you let, all of your men work from home and your women have to stay in the office, even if it was never intended to be discriminatory, it can look that way. And I think you have to be extra mindful whenever you're making those decisions. It's the same as providing support for employees that are working from home. The other piece of that is it can be really tempting, knowing that this is a disease that affects different populations differently, to say go to your workforce over a certain age and give them all the opportunity, or tell them that they have to go work from home while you allow younger employees to stay in the office, or to go to people that have pre-existing medical conditions and tell them they have to go home. Again, those are going to be risking that you get opened up to some discrimination complaint in the future. The hard thing with all of this is none of us have ever been through it before. We don't know what that litigation will look like, what courts will do, what the EEOC or the Texas Workforce Commission, we don't know what they're going to do. But what we do know is that we didn't throw all these rules out the window. And if it looks like discrimination against a certain class of people, there's probably a pretty good risk that you could get in trouble for it. So communicate with your employees, be consistent with your application of the rules, and just continue to read and stay on top of the information and the material that's coming out there. And if you need help, reach out to someone like one of us, because we're happy to help navigate these issues and answer questions for you. And with that, treat your employees the same. You're going to be okay. And I think we can answer some questions.
Awesome. Baili, Leigh, thank you both for riding through this with us, and appreciate the audience as we encountered some of that technical difficulty. I forgot one key thank you when we started this, and that was for the Bryan College Station Chamber of Commerce and for the Gulf Coast Network, SBDC, especially the Brazos Valley group. They've been influential and helpful in just getting the word out for this, sponsoring this with us, and just partnering to get this going. So again, and one other group is the Employer Flexible Team. They are a PEO firm that's out there, and Jennifer Davis supports and covers the Brazos Valley area, and she and I have worked together for a long time, and just thought this would be a great service. So just want to say thanks to those folks that I forgot to say thank you in the beginning. As we get into the question and answer session, we've received a couple of questions through the chat box as well as over email. And so what I'll do is I'll just start asking some of these questions. For the audience, we're gonna have to stay fairly generic, just based on, number one, any potential privacy concerns, but also just to try and address the broad factors that when you're working with an employee base and you're dealing with a question that may involve, say, one employee or something, there is, as I've always worked with clients on, and again, I'm not an attorney, so let me clarify, I'm just an HR consultant, but what I've always tried to encourage our clients to do is think about the body of work, think about the entire situation that employee is going through, as opposed to this specific instance. And so we're going to be answering some questions that are pretty specific, where we don't have the body of work, where our experts aren't going to have the body of work, so they'll have to do their best to maintain kind of that general response. One question that came up for the team is, let's say that I don't have a lot of written policies out there. I don't have a handbook, or I don't have a whole bunch of written policies that talk about how we're going to handle work from home or just this type of environment. Should I be spending a lot of time getting these policies put together and putting something out there, or what types of communication do I need to do to kind of set a baseline?
So I would say you need to get some plan together. I wouldn't personally put a lot of effort into making it a pretty policy and book, but having some sort of policy that you can equally apply to all of your employees is a good thing to have that guideline out there. It can be a memo. You know, no one was prepared for the entire workforce to have to go work from home. And so even the people that probably had those policies, I would be shocked if anybody was really prepared for what we're dealing with now, and it's changing. They could tell us tomorrow that nobody gets to come in, and then it's a whole different game. But I think that, you know, my advice would be, yes, put something together so that you know and your employees know I'm treating you all the same. But don't lose the forest for the trees here. You don't need to now invent a new whole or develop an entire employee handbook right now today because of COVID.
Okay, great. How about, I have one employee, so I'm in an office environment. My business is considered essential. I have one employee that does professional work for me, and they just refuse to come to the office. Is that considered work abandonment, or just, you know, what can I do about that? And what do I need to think about?
I have actually had this question from family members who were concerned because they had an immunocompromised family member at home. I've had this question from friends, from employees. It's a big concern. You know, under the expanded rights and paid benefits under the Families That Care Act, there are specific requirements that qualify for FMLA leave. And actually there's a question and answer document on the Department of Labor asking this exact question. What if I have someone who doesn't fit the criteria, isn't sick with COVID, isn't experiencing symptoms, isn't caring for someone, or isn't dealing with having to basically homeschool a child? They're just uncomfortable. Do they qualify under the FMLA Expanded Benefits Act? And the Department of Labor said no. So that's your official guidance. No, that person isn't going to qualify for Family Medical Leave Act. Now, how do we apply that to, you know, our practical considerations like Baili was talking about? I think that first of all, you have to consider whether or not you may be violating OSHA by not providing a safe work environment for someone who could otherwise fully work at home and isn't being provided that option and has raised safety concerns. You know, is the employer exposing themselves to potential liability? Maybe. And also just in terms of employee morale, you know, like Darren was saying and like Baili was also alluding to, if you have the ability to make accommodations to an employee, I guess I don't see the downside to it, and that is more practical advice rather than the legal answer is, according to the Department of Labor, that person doesn't qualify for Family Medical Leave Act, and yes, they would be considered, you know, absent from work or not showing up without an excuse. So anyway, those are kind of my thoughts on it. Baili, do you have other ideas on that?
I agree with you.
Great. And again, folks, you know, you do go ahead and feel free if you're able to and you want to respond on chat or you want to submit questions on chat, feel free to do that. We aren't having a ton of questions coming in this round, so it looks like we'll be able to manage it this time.
Well, Darren, I saw a follow-up question about the person that had a general question about someone not wanting to come into the office. And I just wanted to point it out because I've had several employers ask the same question and have the same concern, is when employers are implementing these layoffs and furloughs, obviously a lot of employees are going to apply for unemployment. And is this going to result in an increase in their unemployment insurance premiums in the future? I guess, and again, our answer to that is we don't know. Typically, that is exactly what happens. If you have an employee claim unemployment, then that can affect your premiums. Will there be some kind of disaster exception for employees that were laid off during this time period? Very likely that could happen. And I guess what I've been telling people is I probably wouldn't be making business decisions based on my unemployment insurance premiums at this point. If you can keep them on staff and you can hold out until you get your paycheck protection program loan in place, which is basically that's what that's designed for, then obviously that's what everybody is encouraging to do. If that's not financially possible and you need to do some layoffs and maybe some rehires, it's kind of just what's going to work in your individual circumstance. So I guess the answer to that question is we don't know yet, but it's possible that for sure it could increase your premiums.
Sure. So let's say that my employee wants to work from home, and we'll revisit this a little bit more. They need to work. They're saying they want to work from home. They don't qualify for any of the Department of Labor sides, and they're only able to complete, say, 50% of their job or 25% of their job, or maybe really they just can't. What options do I have? What could I take?
Sorry. So to some extent, I mean, it's going to become just a practical decision for you as an employer. Frankly, you can make the decision that I'm going to send you home and get the best. And as long as you look at, okay, I'm not terminating somebody that qualifies for some protection. I can tell you that if you aren't doing your job, then you can't continue to work for me. I mean, that kind of goes back to us being an employment at will state. It's a hard call. You could have a conversation with someone about reducing their hours or reducing their pay based on that. And then that kind of goes back to the morale thing that Leah alluded to earlier. I think we're all having to make tough decisions. The decision for you might be, I'm going to let you go home. We're going to do our best and see how this works for the rest of this month and hope that we're all back in the office in May, and then reassess at that point. That may be the answer. That might not be financially viable for you, and you may have to look at something different. But I think that that's a really difficult situation that a lot of people are facing right now. Leigh, any additional thoughts on that?
No, I agree with what you're saying. I think even if you maybe implement some kind of reduced schedule. So I've heard, for example, whereas people are working from home 4 days and go in 1 day a week to do those things that can only be done in the office. And they're rotating people through to minimize the number of office workers, that are in there at the same time. That's just a solution that I've heard thrown out that may be able to work in some of these instances we're talking about.
Sure, and I think again it goes and I'll let the attorneys keep me in line here, but as I talk about it with clients, a lot of times it's let's just understand what the entire situation is. Some of the things that I've had employers look at is, how long have they worked for us? What's the performance been as they've gone through the process? How are things? What types of things can we do? How much chaos is it causing in the office to the other employees? Those kinds of things are some of the things that may come into account to evaluate. So, what other laws should we be thinking about for small employees? Let's say less than 10 to 15. Let's say less than 15 employees. What laws should we be taking into account? Let's say family medical leave. Does that apply to me now, or what applies in this current environment that I should go out and maybe Google or try and understand?
A couple that come to the top of my mind are making sure that employers understand that the Family Medical Leave Act expanded coverage now applies to all employers under 500. That's a huge change, and also the fact that it provides for paid leave under certain circumstances. And again, that's a big change. Whereas typically we're used to seeing only unpaid leave as a requirement. So definitely be on top of what the new Family Medical Leave Act expanded provisions are. And another issue that I've had come up with a couple employers is keeping track of time and attendance. So the wage and hour laws still apply. And if you have, for example, people that are on salary, they should be paid their full salary, even if they're only, quote, showing up to work, 4 hours a day. That's still, you're not allowed to dock pay if they are showing up at least part of the day. And for hourly workers, making sure that if your time and attendance program was something that you had manually at your office, making sure that you have something else, even if it's just a spreadsheet, even if it's just an email saying, here's my hours worked, those record keeping requirements and complying with overtime laws and minimum wage laws, those are things that may need to be adapted for work at home type situation.
Great. So you mentioned if I have a salaried employee and they're working less than, let's just say they're working 4 hours a day, and typically our day is 8 hours is what we like to see our employees get in. Can I require them to use their paid time off, PTO, vacation, or sick time?
Not unless you want to switch them off of salaried employee. A salaried employee that works any hours a day is entitled to being paid and not be docked for those hours, is my understanding. Do you have a different view, Bailey, or a different exception?
No, I agree with that. Could be different for hourly employees. And again, that's going to be a policy decision. If you've got hourly employees, they're only working so many hours. If you want to make them, say if they're working 6 hours, and this is hourly, take sick leave for the rest of that time, I guess you could consider it. Again, you just need to make sure that you're doing that consistently across all your employees, but you're just paying them by the hour. So I don't know that there's a huge benefit to you in doing that. Leigh, I don't know if you have any more thoughts on the hourly folks.
No, I agree with what you're saying. Typically, hourly tends to not have paid time off benefits.
Right.
I don't know. It would depend on that individual employee's circumstance, but just to keep in mind the idea that those time and attendance and minimum wage and hour type requirements are still in effect.
Absolutely.
Sure. So the option, I guess, for clarity's sake, let's say that I don't require them to use sick time or vacation time, but I would just pay them that 6 hours, and then they would just take the pay for those 6 hours that they actually worked, and that's what we would pay for an hourly employee.
If they're hourly, yes, you could do
hourly.
That.
Okay.
Yeah. And you may want to consider converting salaried employees to hourly. Of course, in order to qualify as a salaried employee and be exempt from overtime, you have to meet certain requirements, but there's nothing that says that the CEO of the company can't be paid hourly. It's always okay to pay people hourly. So if you do have that would probably also be considered like a furlough. And if their wages did decrease, that could provide them with some ability to file for unemployment. So all those things kind of would interact together, I guess, potentially.
Sure. So if I switch them to non-exempt or to hourly, which means the non-exempt means I think that they're eligible for overtime pay. Is that correct? But if I have someone let's say the CEO, for example, if they're hourly, do I have to pay them overtime?
Good question. I believe that you can pay the CEO hourly and if whenever you have exempt employees, they usually are salary and then
right
overtime. So I guess that's just not a practical way of how that ever comes up. So I would have to look at the statute to answer you.
Yeah.
I feel like that's a softball question, Darren, and you already know the answer and you're trying to get us to
I have experienced it in the past, and
Okay.
I think that you could justify that they You can pay them on an hourly rate, but they would be exempt from overtime law based on, but there's, and I can't remember where it is, but I think it's in the Department of Labor, or if you go to SHRM, Society of Human Resource Management.org, you may be able to find an FLSA test, the Fair Labor Standards Act test. And that's really what will prevent someone or understand who needs to be paid overtime or not, or who's exempt from it. But yeah, it's possible to do that, to pay someone hourly and not pay them the overtime hours, the premium.
You're educating us on that. We learned something new.
Yeah, there you go.
Right. So I had another question that came into mind about furloughing or reducing hours. For a salaried employee, if I wanted to reduce someone from 40 hours a week to say 20 hours a week because we either don't have the work or those kinds of things and they're salaried, is that considered a furlough situation? Or how do I handle that if I want to say, look, we're going to cut everybody's hours back to 50% of what you normally work, and that means we cut your pay 50%?
I would think, yes, they would still qualify for unemployment benefits, and everything I've seen indicates, a furlough or a reduction in hours. They could apply for unemployment.
Good.
Yeah.
Folks, well, I've got one more question, and then if anyone else has any other questions you want to submit, please go ahead and hop in the chat or shoot us an email at covid@versabp.com. Let me just see where that last question went. Let's say I'm going to go back to requiring someone to come into the office or not. Is them being a single parent, is that something that's protected by law if they need to stay at home with their children, or protected by any of the new laws that would require me to allow them to work from home?
The emergency family, the Families First Coronavirus Response Act, there we go, there's the words,
There's a lot of acts out right now.
There's a lot of acts out there. And I probably shouldn't call it, the new act about COVID. That's going to give a parent 12 weeks of leave to care for their child who is missing school or daycare. So that gives them leave. They can go home and not work for 12 weeks and get compensated at 2/3 of their salary. What I'm finding a lot of employers are choosing to do is let them work from home and continue to do their job and get their full pay, as long as, of course, they're doing their work, because the employees probably don't, I would say a lot of single parents, a lot of people with school-age children would prefer to continue working and getting their pay if they can, versus taking a reduction in pay based on the act.
Yeah, just to clarify, maybe you said this, Bailey, I didn't hear you, but the reimbursement or the pay that needs to be provided to someone who's taking leave because of a school-age child is 2/3.
Correct.
Okay, yeah.
Correct.
So,
And it's capped also, right? I don't have the number. I think a maximum of 10,000 for the extent of the leave. And I can't remember what the weekly cap is on that, but it is capped.
Let's see, $511 a day, or $5,110 in the aggregate for the 2-week period. That's the initial 2-week period. And then, of course, they'd be looking at, there is a cap that's specifically set forth for the employees who are taking leave because of a school-age child. It's their 2/3 of their regular rate of pay, up to $200 a day, and $2,000 in the aggregate for the 2-week period, and then multiply that out for the 12-week period.
Right. Rick, I see your question about whether it applies to small employers on the 12 weeks. So not the 2-week leave that is for people that are sick, but on this expanded 12-week leave, there is suggestion that there is going to be relief that you can apply for. They have not, from what I've seen, provided a clear avenue to do that yet. Have you seen anything yet, Leigh?
No, I was just going to say, the act says that the secretary can give an exception. I mean, how you get this exception remains to be seen. But as of, the way that the act is written is, yes, it applies to all employers under 500.
Yeah, and the Department of Labor specifically says on their website, don't send us your documentation, but they don't want it.
Yeah, and folks on the chat, I also just put a link out to the Department of Labor's website that touches on the Families First Coronavirus Response Act, and so it'll provide you a little bit more insight so you can go and understand who and what and how it may impact you.
Just a tip, in general, when you're looking at the DOL.gov, for some reason they're notorious for having, they update their information, but the old information stays out there. So I was actually looking at something this morning that was like, wait a minute, that is not what I thought this was. And so just pay attention, especially for some reason on government websites, pay attention to the date it was posted or the date it was updated to make sure that you're getting the most up-to-date information.
Yeah, I think we actually ran into some of that with the CARES Act applications with the Paycheck Protection Plan, and ran into some of that with the new application that was released on Friday. So very well. Well, I don't see any more questions coming in. I want to say thank you to Leigh and to Baili for joining today and for providing their time and their expertise to the folks that have called in and been able to join us. And again, want to say thanks to the Chamber of Commerce, O'Brien, College Station, Employer Flexible, the SBDC for helping us get this information out there and just drive connection between experts in the community and our small business owners. We'll continue to have this series going until we see the questions and the need to slow down go. So every Tuesday and Thursday at 1 o'clock, we'll offer a new topic. There's also, if you go to the Versa Business Partners webpage where you're able to see the topics that we've started at scheduling, there's a vote section for you to be able to vote on some of the topics that have been brought up to let us know what you want to hear about next, and we'll start working on finding experts in the community to drive some information gathering and get the information to you. So this Thursday, we'll continue the conversation with James Larkin, a CPA, that's going to help us just kind of retouch on the CARES Act, seeing that we're almost a week and a half out, about a half of a week past the applications, and the bank's supposed to being ready to take the application. So hopefully the banks are a lot closer across the board to take applications and get information in. So again, thank you to Leigh, thank you to Baili, thanks to all those that were able to attend today. And if you run into questions or have any feedback, please send us an email at covid@versabp.com. Thanks again, y'all. Appreciate you coming out.
Thank you so much. Thanks.
Aaron.